In my 37 years on the federal bench, I believe is a Reagan appointee, this is the most outrageous conduct by a judge that I have ever encountered in a case in which I have been involved. In summary, Judge Brown has issued a 160-page opinion without giving me, a court of appeals judge, not just a trial court judge like Brown, without giving me, a member of this 3-judge panel, any reasonable opportunity to respond. I will set forth the details and the readers can judge for themselves. The great and powerful President Donald J. Trump has just further improved his win record at the U.S. Supreme Court to 25-2. And by the way, I would suggest the 2, while in all honesty, are genuine tactical losses for Trump. They're not strategic losses for Trump. The 25 wins are all strategic wins for Trump. 25-2 at the Supreme Court since being sworn in as the 47th president of the United States, with yesterday's Supreme Court decision affirming the legitimacy of the new Texas redistricting map that secured yet another 5 congressional seats for Republicans, and perhaps best of all, obliterated the congressional seat for the vile Jasmine Crockett. The Supreme Court decision comes just a few weeks after a 3-judge panel had ruled in a 2-1 vote that the Texas redistricting was invalid, largely because the 2-judge majority was quoting from such ultra-credible sources as the New York Times and other progressive legacy media as evidence of Trump's racism. They just didn't like Trump's hyperbolic rhetoric about the redistricting, and they issued their opinion in the most contemptible and disrespectful manner to the 3rd judge on the panel, who was obliged to dissent after the majority opinion was issued because they wouldn't let him see the majority opinion before they published it. Not the way things are done. So yesterday's 6-3 SCOTUS decision affirms that redistricting map of Texas. I would note that the majority opinion at the Supreme Court, the 6 in the 6-3, is a mere 3 pages. A victorious majority decision. And the dissent is a full 17 pages. More than 5 times as long as the majority decision, because it always takes more to say less, doesn't it? A full 17 pages of estrogenic hysteria in the dissent by the usual tres brujas, the 3 crones of the Supreme Court, Justice Sonia, the wise Latina diabetes Sotomayor, Justice Elena, no, I've never been married, never had kids, why do you ask, Kagan, and Justice Ketanji, I'm not a biologist, how would I know what a woman is? DEI Jackson. Now, this is a little bit of an oddity, this case, because it is a redistricting case. And when an appeal is made, when an objection is made to a redistricting map, we don't follow the normal federal court procedures. It gets appealed to a 3-judge panel. Now, it's not a court of appeals panel. It's 3 judges chosen from the federal judges, chosen from the trial and appeals level. So in this case, the 3-judge panel that voted 2-1 against Texas and against Judge Trump, who just got overturned by the Supreme Court, the judge who wrote that majority opinion was a federal district trial court judge, and the judge who wrote the dissent was a superior federal court of appeals judge, which has some interesting dynamics here as well. So we're going to take a quick look at that 3-judge majority decision just to show you how feckless it is. Just a look at the introduction of the dissent in that 3-judge opinion against Texas, because I covered the whole thing in detail when it first happened. But I just want to refresh your recollection because it too exposes just how contemptible and feckless that 3-judge majority that voted against Texas was. And then we'll jump into the Supreme Court decision itself. So in August 2025, the state of Texas enacted a new electoral map. The plaintiffs suing over the map claim that it's racially discriminatory, asked this court to issue a preliminary injunction tossing out that map and forcing Texas to use its old map. Now, of course, the difference between the old map and the new map is the new map wipes out 5 Democrat congressional districts, turns them into GOP districts, and in particular wipes out the district of the contemptible, vile, nasty woman, Jasmine Crockett. For the reasons explained below, this court in this 2-1 decision does issue that injunction, orders that the Texas map to be used in 2026 elections will be the old map that favors the Democrats, the 2021 map. Interestingly, this decision is doing this on the basis of race, but they quote Chief Justice Roberts. They quote, "The way to stop discrimination on the basis of race is to stop discrimination on the basis of race." And then they go on to use nothing but race to make this decision. By the way, I agree with Justice Roberts. Earlier this year, President Trump began urging Texas to redraw its House map to create 5 additional Republican seats. So right now, there's an interesting tension already, right? Because who redrew the map? The Texas map. Trump didn't redraw the map. The Texas legislature drew the map. But this judge is all bent out of shape because the Texas legislator did it at the suggestion of President Trump. They can't bear it. This is Trump derangement syndrome on full display. Doesn't like that the Trump administration said, you should redistrict this map. Doesn't like Harmeet Dillon, the lovely, gracious, and excellent attorney, Harmeet Dillon, head of the Civil Rights Division, sent a DOJ letter to Texas saying, hey, you have a bunch of existing districts that are unconstitutional because they're unconstitutionally based on race. Majority non-white districts. They were based on aggregating a bunch of minority groups to make sure they were majority minority, and that's not constitutional. DOJ threatened legal action if Texas didn't redraw these districts, which were drawn originally on a race basis. So they're just looking to unwind that. 2 days after the DOJ letter, the governor of Texas added redistricting to a special session. Now, again, they're saying this judge is saying the governor plainly and expressly said he's not doing it for partisan reasons, but is doing it to create these new districts, eliminate these so-called coalition districts where they aggregate a bunch of different minority groups, which is unconstitutional. Now, to be clear, legislatures are always allowed to redistrict, to gerrymander for partisan reasons. That's constitutionally permitted, always. They're not supposed to be creating districts for racist reasons, which of course they do all the time because the federal courts make them do it. The federal courts have twisted the Civil Rights Voting Act of 1965, Section 2. It doesn't say you have to have racist districts, but the federal courts have pretended that they're requiring states to draw racist districts, majority-minority districts, because of the Voting Rights Act of 1965. So the federal courts are what forces the states to create these racist districts. And now this judge is whining about racial objectives that Trump is trying to unwind those racist districts. The legislature dismantled and left unrecognizable not only all of the offensive districts identified by the DOJ, but several other coalition districts. And of course, the net result is 5 additional GOP seats. And this judge didn't like that. Look at this. This is the evidence. By the way, the Dissent, the Sotomayor, Kagan, Ketanji Jackson dissent in yesterday's Supreme Court decision, they make a big deal about how this 3-judge panel, this majority, this district trial court judge that ruled against the Texas map, we should defer to his fact-finding. He spent a lot of time and effort doing fact-finding. Where did he get his facts? He got his facts here. On June 9th, 2025, the New York Times, that's the source of his evidence. The New York Times published an article. Well, that's got to be controlling evidence, saying, quote, President Trump's political team was encouraging Republican leaders in Texas to examine how House district lines in the state could be redrawn ahead of next year's midterm elections to try to save the party's endangered majority. That's perfectly constitutional, by the way. Contemporary, close quote. Then the same judge cites other unnamed contemporaneous press coverage You know what that is? That's just the progressive fascist legacy media, the TDS legacy media. That's what drove this district trial judge's decision against the Texas map. It indicated that partisan rather than racial motivations were behind the White House redistricting push. Again, political drivers for redistricting are perfectly constitutional. And of course, done by the Democrats, have been done by the Democrats for decades, aggressively. You look at all of New England, it's 100% blue, 100% Democrat congressional districts, even though 40% of New England votes Republican. Zero Republican representation in the House from any New England state. It's almost as egregious in California, where roughly 40% of Californians vote Republican, but they have something like 15% of California's congressional seats. And of course, California has now, with questionable legality, further gerrymandered the state in favor of Democrats. We'll have to see if that survives. It's under court challenge right now. The same New York Times article. What could be more credible than a New York Times article talking about Donald Trump? Reported that the push from Washington had unnerved some Texas Republicans. Is this a statement of fact, or is this a description of a purported emotion? Or you're not allowed to redistrict if you're doing it while you're unnerved? The push from Trump had unnerved some Texas Republicans who worried that reworking boundaries of Texas House seats to turn Democrat districts red by adding reliably Republican voters from neighboring Republican seats could backfire in an election that is already expected to favor Democrats. They expect the midterms to favor Democrats. At an emergency meeting at the Capitol shortly before the New York Times article was published, so if it was before the New York Times article was published, the New York Times article could not have influenced this emergency meeting, right? Congressional Republicans from Texas, they professed little interest in redrawing their districts. According to who? According to the New York Times. In fact, at the bench trial, this court held, meaning this three-judge redistricting appeal court, when counsel asked a Texas senator whether the Texas legislature might be considering redrawing congressional districts, as the New York Times had reported, she said unequivocally, they are not. Well, that should control everything, shouldn't it? Then they talk about Harmeet Dillon's DOJ letter, in which she informed Texas that some of their congressional districts were unconstitutional and needed to be corrected. And look how personally insulting they are. It's unchallenging. This unelected black-robed tyrannical inferior district trial court judge writes, it's challenging to unpack the DOJ letter because it contained so many factual, legal, and typographical errors. Indeed, even attorneys employed by the Texas Attorney General, who profess to be a political ally of the Trump administration, described the DOJ letter as legally unsound, baseless, erroneous, ham-fisted, and a mess. I wonder what kind of assessment Harmeet Dillon would write about this just overturned opinion. The gist of the letter, though, is that the DOJ is urging Texas to change the racial compositions of certain congressional districts to make them constitutional. Now, again, who did the redistricting? It wasn't the DOJ. It wasn't Harmeet Dillon. It wasn't Trump. Texas did the redistricting. If Trump sends them a letter saying, I'd like you to do this for, let's say, illegitimate reasons, and Texas redistricts but has legitimate grounds, that's a legitimate redistricting no matter what some DOJ letter said. But this judge wants to rely entirely on that DOJ letter to overturn the Texas map. Besides those legal errors that they obviously turned out not meaningful because the Supreme Court just overturned this decision, the judge goes on. The DOJ letter also contains factual inaccuracies. But again, the DOJ letter is not what redistricted Texas. The Texas legislature is what redistricted Texas. That's the majority decision that was just overturned. Now, let's get to just the introduction part of the dissent to that decision. So this is the dissent to that two-judge majority opinion written by that unelected black-robed tyrannical inferior district trial court judge who based his ruling on New York Times articles. Absolutely insane. And he doesn't like Trump. He doesn't like that Trump sent a letter to Texas suggesting they redistrict. Just very personally upset about all that. And even worse was how contemptuous the two judges in the majority, particularly the trial judge who wrote the opinion, contemptuous of the third judge on the panel, who's actually a higher level Court of Appeals judge. And I'm going to let that judge describe for you. He had to file a separate dissent because of the feckless and vile behavior of the two-judge majority, or in fairness, at least of the one judge who wrote the majority opinion. Jeffrey Brown is the bad guy. Jerry Smith is the good guy. Jerry Smith. And he starts off, fasten your seatbelts, it's going to be a bumpy night. He says, I dissent from the entirety of Judge Brown's opinion granting a preliminary injunction against the map. By the way, it's very common in a dissent for the party dissenting, the judge dissenting, to start off by saying, I dissent. This is a dissent, right? He mentions it here, and he mentions it in the first substantive sentence. And then at the end, it's common for them to say, and this is why I dissent. What they don't normally do is repeatedly, throughout the entire dissent, say over and over and over again, I dissent, I dissent, I dissent. And I want you to see, I'm going to do a word search in real time. How many times appellate court judge Jerry Smith says the word dissent? It's found on 26 pages. 26 pages. This dissent is 100 pages long. So on average, every 4 pages. And how many times I dissent in particular? On 15 pages, he writes, I dissent, I dissent, I dissent, I dissent. That is not normal. And it's not normal because it's required because of the egregious nature of the majority opinion. Preliminary statement, and that's the only part of this we're going to take a look at because I did this whole dissent in detail when it first came out. He says, I append this preliminary statement to dispel any suspicion that I am responsible for any delay in issuing the preliminary injunction or that I am slow walking the ruling. I also need to highlight the pernicious judicial misbehavior of U.S. District Judge Jeffrey Vincent Brown. Folks, this is not how federal judges talk to or about each other. They at least fake respect. An explicit calling out of pernicious judicial behavior, by the way, which is sanctionable by the Article 3 judicial branch internally, is not done, except when it must be done. As what's his name said in Roadhouse. Who was the guy in Roadhouse? Patrick Swayze, right? Be polite, be polite, be polite. Until when? Until it's time not to be polite. That's what's happening here. Let's continue with Judge Jerry Smith. In my 37 years on the federal bench, I believe is a Reagan appointee, this is the most outrageous conduct by a judge that I have ever encountered in a case in which I have been involved. In summary, Judge Brown has issued a 160-page opinion without giving me, a Court of Appeals judge, not just a trial court judge like Brown, without giving me, a member of this 3-judge panel, any reasonable opportunity to respond. I will set forth the details and the readers can judge for themselves. This 3-judge district court held a 9-day evidentiary hearing on a motion for preliminary injunction against the Texas map. That hearing was concluded on Friday, October 10th. The judges immediately retired to confer. Judge Brown and the second judge in the 2-judge majority, Guadarrama, voted to grant the preliminary injunction. I voted to deny. It was understood that the majority judges would begin putting together a majority opinion. During the next 26 days, there was silence, nary a word from either judge. And then suddenly on Wednesday, November 5th, Judge Brown sent me a 13-page outline so that you, the dissent, and your chambers might be able to prepare your dissenting opinion, then nothing else for a week. On Wednesday, November 12th, Judge Brown sent the message saying, we're anticipating issuing our injunction 3 days later. On Saturday, November 15th, we'll try to get you a draft before we issue it. What? Whether or not they get this dissenting judge, Smith, a draft of the majority opinion is entirely within their control. Nobody's going to stop them. What's the try? What's the endeavor? They say, sadly, we do not believe we can wait for your dissenting opinion before we rule. The fuse is simply too short in light of Purcell. Purcell is a federal court decision that says, Supreme Court decision, that says to not make changes in congressional maps right before an election because it's too disruptive. So what the majority is claiming here is, listen, we're not supposed to make changes right before an election. The election's coming up, so we have to issue our order right now so we don't violate that rule against not changing things just before the election. They say, we will note, however, that you will be dissenting. We're not trying to cut you out, my ass. We just don't have the time. By the way, they wasted a full month, 26 days, then another week, doing nothing. So if there's any cause of a shortage of time, it's in the majority. They continue, of course, we'd have liked to have seen your dissent before we issue our opinion, but that will also be impossible. We cannot bear to wait to see what your objections are to our arguments before we issue our arguments. That's not how it's done, folks. As we'll see when we look at the Supreme Court decision, it's obvious that the 3-page majority, 6-3 majority at the Supreme Court that overturned the majority decision here invalidating the Texas map, they referenced the dissent. So they were given the Kagan, Sotomayor, Ketanji Jackson dissent to read, and they address arguments from the dissent in their majority decision. And the reverse would also be true. That's how it's done. You share your arguments with the other side before you publish, so everyone has a complete understanding of where everyone stands and has an opportunity to address opposing arguments. Back to Judge Smith. Yes, you heard that right. To summarize, in case the reader doesn't get the point, Judge Brown was announcing he would issue an opinion 3 days later, an opinion I hadn't even seen and might not be furnished before issuance. This is unthinkable, but it occurred, and not accidentally. It was deliberate. A day later, on Thursday, Judge Brown sent a message saying, I've attached a draft of our opinion and the order granting the preliminary injunction against the Texas map. We still have revisions to make, but we wanted to get this to you to assist you in your preparation of your dissent. The draft was 168 pages, 655 footnotes, and the final version was going to be published 2 days later. This was the very first actual opinion draft I had been allowed to see 5 calendar days before the actual opinion was sprung. I was out of town on Thursday and Friday to attend a funeral of, coincidentally, a federal district court judge out of Texas. I was driven all day Thursday. In my absence, my staff continued to work. I drove home on Friday, arrived after midnight, so my staff and I could spend all day Saturday and Sunday working on the dissent. On Sunday morning, Judge Brown sent a message saying, I've attached a new draft of our majority opinion. We're still making revisions. We're now hoping to issue it the following Tuesday. The second draft was 168 pages and contained substantial revisions from the first draft just a few days earlier that Judge Smith, and his team had been working on. I replied I'd been out of town, was writing the dissent all weekend, would be on the road all of the next day, Monday, to attend graveside services for the same judge's funeral. I said Judge Brown had no business issuing an opinion as soon as Tuesday. On Tuesday, Judge Brown wrote the following. I've attached a final version, yet another version. We still intend to issue it today. I'm sorry we can't wait on your dissent. Purcell compels us. That third version, 160 pages, was issued a few minutes later. This outrage speaks for itself. Any pretense of judicial restraint, good faith, or trust by these two judges is gone. If these two judges were so sure of their result, legal result, they would not have been so unfairly eager to issue the opinion without my dissent. Or they could have waited for the dissent in order to join issue with it. What indeed are these cowards afraid of? Judges on multi-judge courts, which this judge is, right? Judge Smith is a court of appeals judge, so he's normally on a 3-judge panel. The district judges, the other 2 on this panel, are normally trial court judges, not normally on a multi-judge court. Judges on multi-judge courts understand how important is the deliberative process to fair and accurate judicial decision-making. As I say later in this dissent, judges get paid to disagree as well as to find common ground. Judges in the majority don't get to tell a dissenting judge or judges that they can't participate. If the two district trial court judges on this panel get away with what they have done, it sets a horrendous precedent that might makes right and the ends justify the means, which of course is the progressive fascist prime directive. Continuing with Judge Smith here, the majority might even say, we don't need to wait for your dissent, and we wouldn't read it if we did. Here, that sort of happened. The entry on the district court docket brings up only Judge Brown's majority opinion. The reader has no access to this dissent without opening a separate, non-consecutive docket entry. Normally, the majority in the docket would be in one document, as we're going to see with the SCOTUS decision. So this majority has won in terms of diminishing the impact of the dissent and the public's access to it. In the interest of justice, one can only hope it is a Pyrrhic victory, which of course it turned out to be. The Supreme Court reversed it. You think any of these shenanigans contributed to the Supreme Court's willingness to reverse this? I mean, it probably shouldn't on the legal merits, but you think it did? You think this kind of contemptuous conduct by these federal district trial court judges, especially to a superior court of appeals judge, played a role in the Supreme Court's willingness to overturn the majority opinion here? How could it not? Judge Smith concludes here in his preliminary remarks, when I was newer on the bench, a friend asked me, now that you've been a judge for a few years, do you have any particular advice? And I replied, always sit with your back to the wall. The main winners from Judge Brown's feckless opinion are George Soros and Gavin Newsom. Ouch! The obvious losers are the people of Texas and the rule of law. And again, he repeats, I dissent. I dissent. By the way, there's another joke along these lines. I don't remember if he made it in this opinion, but it goes, what's the difference between a federal judge and God? Anybody know? Any lawyers out there in the chat today? If you're a lawyer, you know. The answer is God doesn't think he's a federal judge. That's the difference.